In the last lecture, I gave an overview of the Fifth Amendment and the various freedoms associated with it. Now, your textbook doesn't actually talk very much about the Double Jeopardy Clause or about the Takings Clause, so I'm going to take a moment now and discuss a couple of key cases in those areas. So to recap just very briefly, the Fifth Amendment addresses a variety of different rights and liberties. So as you can see on the slide, here's the text. So the first one that we're going to talk about today is the Double Jeopardy Clause, right? So this is the point at which the text says, "Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb." We'll discuss self-incrimination in more detail in the next voice thread. But I also want to now draw your attention to this final clause of the Fifth Amendment, which is referred to as the Takings Clause. And so the text here reads that no person shall be, and I quote, "deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." So as I mentioned previously, the Fifth Amendment seems to include a number of rights that aren't very closely related. But I think that we can find some common grounding for these rights. One common feature of all of these rights, whether it's self-incrimination or the protection against double jeopardy, or the requirement that the state compensate property owners if their property is taken from them, is that it outlines a certain sphere of dignity for individuals. Each of these things would be a fairly egregious violation of individual rights in and of itself. And so we see these grouped together, again, not as a completely random assemblage, but as an acknowledgement that individuals have certain inviolable rights against the government, right? This is what much of the Bill of Rights is about. And so we see a few of these outlined here in the Fifth Amendment. So moving on from here, we're going to start with double jeopardy. So there have been a few notable double jeopardy cases in the 20th century and now the 21st. So the first kind of like landmark case in double jeopardy comes from a case called Blockberger. And this simply establishes some limits on what being tried for the same offense twice actually means. So this seems fairly straightforward, but actually there are some complications. So what they found in the Blockberger case was that to use the same evidence collected to try a defendant more than once for the same crime is permissible, but only if it is within the same trial. So this refers not so much to having more than one trial as to having more than one use of the same set of evidence. So that remains in place. The next important case that comes along is in 1959. So in 1959, this case, Abate v. United States, established what is now referred to as the separate sovereigns doctrine. So what does this mean? Well, this actually looks an awful lot like being tried twice for the same crime. So what the court found in Abate v. United States was that the federal government and the state government are two separate sovereigns. They're not one entity. And so because they're separate sovereigns, each one can try a defendant for the same conduct, right? So this is the term that's used. They don't want to say you can be tried twice for the same offense because that would seem to fly directly in the face of the Fifth Amendment. But these two separate sovereigns can try a person separately, so once at the federal level, once at the state level, for the same conduct without violating the Double Jeopardy Clause. Obviously, this is a somewhat controversial finding. And so in 2018, the court was sort of invited to reconsider it in Gamble versus United States. However, in 2018, the court went ahead and declined to overrule the separate sovereigns exception that was established in Abate. And so that was reaffirmed, and the separate sovereigns exception remains. So that means that a person can, in fact, be tried twice for the same conduct, so long as it is being tried once by the federal government and once by the state government. So next we'll take a look at the takings clause. So just to refresh your memory, recall that the Fifth Amendment states that a person shall not be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation. Okay, so private property shall not be taken for public use without just compensation. That doesn't mean that the government can never take your property. It just means that there are limits on when private property can be taken from individuals by the government. So we see two limits in particular. One is that it has to be taken for, and I quote, public use. And the second is that it has to be, or it may not be taken without just compensation. So just compensation is generally treated to mean something like fair market value. But what about public use? So we'll return to the question of public use with Kelo versus New London, which is probably the most famous takings case. It deals with eminent domain. But first, let's take a look at a case that is a little bit closer to home. So this is a case from 1992. It's called Lucas versus South Carolina Coastal Council. So as you can see on the slide, here are the facts of the case. These come from OIA. But this was also, mind you, well before the recent real estate boom in Charleston in the last 10 years. But I think we can sort of like relate to this case now. So in 1986, Lucas bought 2 residential lots in Isle of Palms. So he meant to build single-family homes on the lots. However, in 1988, in an effort to combat some of the troubling environmental impacts that we've seen here in the Low Country, the state legislature adopted a law that would ultimately bar Lucas from building any permanent habitable structures on that land. So the purpose of this law was to prevent the destruction of the barrier islands, to prevent erosion, and the sorts of effects of climate change that we are currently seeing. But this left Lucas in a bad position. So he had spent a lot of money on these lots with the expectation that he would then be able to get that value back out of them. And to get that value back out of them, it was necessary to build the homes that he'd planned to build. So Lucas argued that this was a prohibited taking under the Fifth Amendment, that the government couldn't just sort of like take, maybe not the land from him because he retained possession of the land, but that the government couldn't take the land's value from him. Their prohibitions on how he was able to use that land ultimately rendered it valueless to him. So he appeals this in court. So this is ultimately appealed up to the Supreme Court. And the question that this case raises is whether or not this ban, which deprived Lucas of all economically viable use of his property, qualifies a taking under the Fifth and 14th Amendments that would require, and I quote, just compensation. So in this case, the court agreed with Lucas. They said yes. This law had not taken the possession of the land from him, but it had stripped the land of any economic value to him. And so this, they said, qualifies as a taking under the Fifth and 14th Amendments. So just as an aside, recall the reason why we're mentioning the 14th Amendment here is that this is the amendment that applied the Bill of Rights to the states, right? So this means that both the federal government is bound by the takings clause, but so are the state governments, which was important in this case because the other entity involved was the state of South Carolina. So there's this useful quote here from the decision that outlines the court's reasoning. So when the owner of real property has been called upon to sacrifice all economic beneficial uses in the name of the common good, he has suffered a taking. Right? So in this case, the court found that losing the value of the land, again in this case for the public good, still qualifies as a taking, and found that the government was required to compensate him fairly for taking his land. So this brings us to Kelo versus New London, which is probably the best known takings case, right? So this took place in 2005 in Connecticut. So this is an eminent domain case. You've probably heard the term eminent domain before. Eminent domain refers to a power that is held by the government to seize private property. So this is usually held by municipal authorities rather than state or federal authorities, and usually the kinds of uses that property that's seized under eminent domain is put to would be things like maybe building a freeway, or an airport. So often it's building infrastructure. So very clearly a taking that is done for quote unquote public use. But this case is a little bit different. So what's unusual about the Kelo case is that this property was being seized from private owners, um, but then it was being turned over to private entities to develop. So the question that arises in Kelo isn't whether or not this is a taking. It's clearly a taking. People's homes and property were being seized under eminent domain. But the question is rather whether that taking is actually justified by quote unquote public use. So here's a little bit of background. New London, Connecticut was in the throes of an economic crisis. Unemployment was high. There just wasn't a lot of money circulating in the economy. And so the city was desperate to do something to improve the situation of the entire city at large. So one of their ideas to do this was to seize some land that wasn't blighted, right? So this wasn't land that was sitting unused. It wasn't, like in a state of disrepair, but rather to seize some land that wasn't being put to maybe productive economic use and repurpose it in that direction. So the city of New London used its power of eminent domain to condemn Kelo's property and then turn the use of it over to the New London Development Corporation. Now, the New London Development Corporation was a private entity. So here we see the central question of Kelo arise. Does public purpose equal public use? Or should public use be interpreted more or less broadly? So, okay, to unpack this, let's go back to the situation that New London was in. So again, it's in dire economic straits, high unemployment, not a lot of tax revenues. So the city is looking to solve this problem. Well, their argument is that if they take this land that is not currently being used for economic benefit and develop it, that would create jobs and increase tax revenues. So this is a sort of like indirect benefit kind of argument. We can see a direct benefit coming from building a freeway. We can see a direct benefit to the rest of the community, to building, say, a municipal airport. But this is more of a sort of like diffuse benefit. So they argue that by developing this land, by making it economically productive, everybody in New London benefits. And so that is sufficient, right? That's sufficient to meet the public use requirement of the 5th and 14th Amendments. Kelo and the other property owners obviously disagreed. They argued that, regardless of the sort of like indirect secondary benefits that might come to everybody, right, the city at large, as a result of having this private entity develop the land, nonetheless, this was taking private property to sell to private developers. And they say this is just not public use. So ultimately, and perhaps somewhat surprisingly, the court found in favor of New London. And so this led them to an exploration of what public use actually means. So they could have construed it very narrowly, right? So a narrow construction of public use might be saying something to the effect that, the benefits of the taking have to be sort of like produced directly by a government entity, and that, handing that property over to a private developer, removes the public part of that public use. But that isn't what they did, right? So they didn't construct it very, very narrowly. But rather they expanded the definition of public use to what they term public purpose. So if you read the opinion, again, it's a plurality opinion. This was a really controversial case. But Justice Kennedy offers a concurrence where he tries to really develop this concept of the court's approach to public purpose, and he draws on a number of different cases, right? So he, for instance, refers to Romer versus Evans, which we will discuss later in this course, and a couple of other cases where there's an exploration of like what a public or government purpose legitimately can be. But in Kelo versus New London, they did set this precedent that the public use requirement of the Fifth Amendment can be interpreted pretty broadly. So I would like you to kind of like reflect on the Kelo case. I think this is one that particularly provokes emotional reactions in people. So put yourself in Kelo's position. You have a house. You've made that house into exactly what you wanted. Maybe it's been in your family for generations. So even if you're compensated for it, fair market value, you didn't want to sell it, right? So having your property taken from you, even if you're compensated fairly, I mean, isn't this still a sort of like basic violation of, your autonomy, right? So your willingness to sell or not sell your property. And arguably, to sort of put this maybe more strongly and provocatively, like even your dignity as an individual, right? So this is like an important decision that hasn't been left to you. It's just been taken out of your hands. So what do you think about eminent domain? How much public benefit is enough public benefit to justify taking someone's home from them? And how direct does that public benefit need to be? Should we ever have private for-profit entities involved in takings cases, or is this something sort of inherently suspect? So that concludes our brief exploration of double jeopardy and takings. In the next voice thread, we're going to look at some cases related to self-incrimination. So I raised some questions in the overview lecture about what actually constitutes self-incrimination, right? And so according to the standard, there are two key elements. So number one, there has to be testimonial evidence that incriminates the person providing it. And then two, that evidence has to be compelled by the government. Well, this all seems fairly straightforward, right? So the government shouldn't be able to force you to speak words that ultimately incriminate you and make you subject to punishment. This is a violation, again, of your sort of like basic dignity as an individual and your autonomy. Clearly forcing you to do a thing that is not in your best interest and that you don't want to do. But this question of testimonial evidence always arises, right? So testimonial evidence is clear when you're speaking, right? Or when you're writing, but what else might constitute testimonial evidence? So, there's this sort of recurrent problem of biometrics. So gaining access to a phone through fingerprint readers or facial recognition, can that actually be considered testimonial communication if it's nonverbal? But nonetheless, there is this information, right? So we probably don't often think of our faces or fingers as information, but there is this information that we are in possession of that is then being taken, from us in a compelled way by a government actor and then used to incriminate us. So it looks an awful lot like self-incrimination under the Fifth Amendment. Anyway, so we're not going to discuss so much the biometrics in the next lecture, but we are going to look more closely at interrogations, what role counsel plays, and whether or not someone has sort of been fairly or unfairly compelled to incriminate themselves, etc.